Good evening and welcome to the Hutchinson Legal Victorian Law Week presentation. My name's Deborah and I'll be supporting Jason, our presenter tonight. Before I pass on to Jason, there are some basic housekeeping items. This presentation is being recorded and will notify registered attendees of its availability in the coming week. All attendees are muted and cameras are off for the duration of tonight. If there are any questions, Jason will answer them at the end and you can pop them into the question function throughout the session tonight. And finally, after tonight's session, a survey will be made available. Please provide your feedback. This will help us improve our future information sessions. Now, I'd like to introduce to today's presenter, Jason. Jason is an Institute of Victoria accredited specialist in wills and estates law. Jason practices extensively in complex estate planning and estate litigation. He is known for providing clear advice, strong advocacy, and compassionate support to his clients during difficult times. Tonight, Jason will be presenting to you all on estate plans. Thanks, Jason.
Thanks very much, Deb, and good evening to you all. Thanks for joining us on a chilly, well, it feels like winter's night. We're not quite in winter yet, but it certainly feels like it. Wherever you're joining us from, and I know we have people from around the state and even interstate, so it's great that you could be with us tonight. I've got a number of slides here tonight, and these will also be made available to you after the presentation. But I'd love for this evening to be as practical and relevant as we can make it. So please do take advantage of the question and answer box there. Pop your questions in there. And I might not be able to answer them as we go along, but we'll certainly do our best to get to them at the end. This is an area that I really enjoy talking about. It's an area that, as Deb said, I practice in extensively. And tonight we've intentionally used this title of an estate plan. Why do you need one? Talking about an estate plan, because like so many things in life, this area of the law is not as simple as maybe it once was. It used to be that you just needed to get a will and that was fine. But nowadays, in so many circumstances and in many situations, that just doesn't cut it. You need to think a lot more broadly and a lot more expansively, and there are so many other factors at play. And so tonight we're going to explore some of those and hopefully just open your eyes to some of the different things that you should be thinking about as you contemplate your personal arrangements and how to prepare and provide and protect yourself and your family and loved ones. And so let's get stuck into it. We'll start with the obligatory disclaimer because after all, we are lawyers, and it's simply to note that circumstances vary, and so because of that, advice can vary. And so tonight we're just going to be giving you general information, and you really need to potentially be getting special advice that's tailored to your circumstances. And so we just make that clear at the beginning. When you're talking about estate planning, the first thing that many people will think of course, is a will. And in its simplest form, a will is just a legally binding document, which in most cases will distribute your assets and say who gets what upon your death. It's a way of you being able to have some say in that decision and some control over who benefits. Another significant aspect of a will is that it appoints your executor. And that may be the same person as the beneficiary or the beneficiaries. You can have more than one executor. You can have, in fact, 3 or 4 executors if you really want to. There can be pros and cons to that decision. But an executor has a number of functions, including arranging funeral, dealing with your personal assets, administering the estate, paying bills, paying debts, paying liabilities, and making sure that the people who should benefit do benefit. And in many cases, the executor will have the job of applying for probate of the will as well. They're the parts that people generally think of when they think of an executor, but the power of an executor can go beyond that as well. For example, an executor has the power to replace the single director of a company in some circumstances. So for example, if you were the sole director and the sole shareholder of your company, then your executor has the power to appoint a new director in your place when you die. And so that means that in many cases, an executor can effectively continue to run the business of the deceased person. So that might impact your choice of executor. You start to think, oh, this person's not only going to be wrapping up my personal affairs, they're also going to be dealing with my business. You need to make sure they're appropriate and they have the knowledge and skill to be able to do that if that's required. In some cases, an executor will have the control of your self-managed super fund. They may exercise the powers of the trustee. In some cases, an executor can even take control of a discretionary trust, like a family trust, or maybe even a non-discretionary trust, like a unit trust. And so the powers of executors can be quite significant. Because of all this, you really want to make sure that your executor is someone that you trust, in whom you have great confidence, who is capable and is up to the task. And as I say, you can have more than one executor. In some cases, that's a good idea. You can also sometimes have professional trustees, like one of the trustee companies. That can be an option. Some people even turn to their accountants or solicitors. There can be pros and cons to all of these options, but they're things to bear in mind. So the appointment of the executor is one part of the will, and then obviously that question of who gets what. One of the questions we're often asked is, well, do I actually really need a will? What happens if there is no will? Well, there can be a couple of implications. One of the first issues is that if there is no will, then there is no executor. By definition, an executor is only appointed in a will. So if there is no will, there is no executor. And what that means is that it's not immediately clear who should be the person to administer your estate upon your death. Usually it'll be the person who has the greatest right or entitlement, but that might not be who you want to be making decisions. For example, and I've dealt with a number of these situations recently where the deceased person was separated from their husband or wife, but they'd never got around to being divorced. And so that meant that effectively their ex was entitled to letters of administration, entitled to administer the estate of the deceased person. That might not be appropriate. It can be a problem if there's one family member who's very close to the deceased person and the others are estranged. And again, that might not be appropriate for those estranged family members to have some kind of say or control in the administration of the estate. And so it can lead to fighting over and clarity over who has the greatest interest in the estate. It can lead to court proceedings even, and obviously all of that leads to delay and increased costs. Most of us, I think, will agree that that's to be avoided if possible. Not only do you not have an executor appointed if there's no will, then there's the question of who benefits, who gets the assets of the deceased person. This is governed by what we commonly refer to as the law of intestacy. There's a formula that's set out in the Administration Probate Act 1958. And there are a few different permutations depending upon the family circumstances of the deceased person. In a nutshell, generally, in most cases, if the deceased person has a partner and has children with that partner, then the partner will take. But if the partner of the deceased person at death is not the parent of the children, then the partner will get the chattels, personal effects. They'll get the first $539,000. They'll get half of the remaining estate. The other half goes to the children. And there are many times I've seen issues with that. There can be issues where there's multiple partners even. And you might question that and wonder how that could be, but it's very easy to do, particularly nowadays. If the deceased person was, as I said before, was legally married, but not got around to being divorced, had separated from their first husband or wife and then repartnered, then you've got two partners. And sometimes there have been cases where the de facto status extends to potentially even multiple partners, and then you can really have a mess, as you could imagine. And if there's no will, then it's up to everyone to fight over it and try to make their argument for who should benefit. If there's no partners and no children, then the law sets out a whole progression of ever expanding family members, parents, siblings, grandparents, nieces, nephews, aunts, uncles, cousins, grandchildren of deceased siblings, and at the very end of the list, the state will be the grateful beneficiary of your estate if there's no one else to take a benefit. I can't speak for you, but in my entire professional career, I've only met one client who wanted the government to be the beneficiary. And so to avoid that, it's a really good idea to remove the question, remove the doubt, and make a will. As I said earlier, however, making a will is not really sufficient. It's a great start and it's a very important part of the whole process, but simply making a will doesn't necessarily deal with all of your assets adequately. When I talk about estate planning, our first step is to actually look at what you own or what you intend to own and look at the structures that you have in place. For example, jointly owned assets are not usually dealt with by a person's will. They automatically roll over to the surviving joint owner, and that can apply to property, that can apply to bank accounts, that can apply to other assets as well. And so that can have significant impacts, both favourably and unfavourably. I remember many years ago now talking to one client, and I should say I'll tell you a number of stories here tonight. They've all been anonymised, so if you think they remind you of someone that you know, it's not them. But I can tell you, about a gentleman who had remarried late in life to a much younger wife. The only real asset he had was the property that he owned jointly with his adult son. And when he died, ownership of that property automatically rolled over to that adult son. In his will, the gentleman had said, I leave everything to my wife, but the problem was he didn't really own any personal assets. And I had to explain to his grieving wife, crying wife in my office, that she wasn't going to get anything at all. And she was absolutely distraught. And as we went back to the lawyers who'd prepared the will and went back through their file notes, they'd had a discussion with him and they'd said, you're going to leave your wife really exposed. And he said, no, I can trust my son, he'll look after her. Famous last words, perhaps. So you need to consider what's the impact of joint ownership, and is that a good arrangement or is it inappropriate? Sometimes that should be changed to a tenancy in common, and there can be arrangements made to give a surviving partner merely a right to occupy a property, to live in it for their life, but ensure that the property eventually goes to, for example, children of a prior relationship or something like that. These are some of the considerations that should be had. Other things to consider would be residential care considerations and ensuring that, particularly as a couple move into their twilight years, making sure that there are adequate funds that are available to meet their needs, to provide for their care, but also to provide certainty to the family situation and ensure that ultimately assets do pass to the correct beneficiaries. Another reason to consider a careful estate plan is to look at the situation of the beneficiaries themselves and how this inheritance will impact them. One of the impacts of bankruptcy law is that if a beneficiary is bankrupt at the time that the deceased person dies or afterwards, then all of that inheritance will go to the trustee in bankruptcy. It will go to be applied to the outstanding creditors, and if there's anything left after that process and after costs, then the beneficiaries might get something. And so a careful estate plan also looks at the beneficiaries, their circumstances, their situations. And so you want to look more broadly than just simply saying, yeah, I give everything equally to the kids or whatever you might intend to do. Another part of our lives that isn't automatically dealt with by a will is the area of superannuation. And this is an interesting one because superannuation is relatively new. If we talk about wills, People have had wills and have been fighting over wills, and the law of wills is well developed. It's been there for 300-400 years without really significant changes in many cases. But superannuation is a much newer thing, and we're only now sort of getting to the point where we're starting to see larger superannuation balances. And even for families who wouldn't consider themselves wealthy, it's pretty easy for superannuation to be the largest asset after, say, the family home. And what people may not realise is that a will does not automatically deal with superannuation, and rather, unless you've taken steps to deal with it, the trustees of a super fund have discretion to deal with the funds as they consider appropriate. Now, sometimes that's a good arrangement, sometimes it's not. I've seen situations where under the will, mum and dad left everything equally to the two kids, 50-50. And the trustees of the super fund said, oh, this one needs it more than the other, so let's split it 80-20. And they can do that. I had one matter where a father died. He had 5 children under the age of 18. He had been the sole breadwinner of the family, and so mum was left to raise these 5 children by herself. And she had a mortgage to pay, she had mouths to feed, and the trustees of the super fund said, we think that we'll divide the super equally between mum and the 5 kids, and the kids' money will be all locked up until they each reach 18. Clearly not the best decision. And so we were able to appeal that decision and ensure that mum had access to the money that she needed to raise the family. But it just raised another, brought in another level of complexity, delay, cost, and stress that mum really didn't need in those circumstances. So a careful estate plan looks at superannuation. In some cases, it's a good idea to make a binding death benefit nomination to a particular family member, to say the surviving spouse, to the children. But in other cases, there can be tax advantages to not doing it in that way and in trying to make sure that the super gets paid to some people and not others. And then again, if you're anticipating some kind of litigation, then it might be a good idea to ensure the super is dealt with far away from the will and the estate. And so that can be a strategic decision as well, and a consideration that should be had. Sometimes you might have heard of the term testamentary trust will. I won't go through this in great detail tonight because I'm trying to keep moving so we can get to your questions. And I can see we've got some questions coming through. Please, as I said, continue to feel free to pop those up. But just briefly touching on testamentary trust wills, there are some structures that we can use to great benefit of beneficiaries. And rather than just gifting assets to beneficiaries directly, sometimes it's advantageous to transfer the assets to a trust, which the beneficiaries can then control and use on into the future. Sometimes that might be one trust that the beneficiaries share. Sometimes each beneficiary will have their own trust. And there are a couple of reasons we might do that. One is that, according to tax legislation as it stands at the moment, that allows for income from the trust to be streamed around the family group. And so it can be paid to particular beneficiaries who might have a lower marginal tax rate than others. And so that can be very helpful, particularly if you have beneficiaries who might have significant personal income, and if they have other family members who don't, maybe a partner or children, then that could be really helpful to minimise tax into the future. I was talking with a family just in the last few weeks, and their loved one has died, and they've set up this testamentary trust, and they may save $400,000 to $500,000 in the next 7-8 years, based on the preliminary advice the accountants have given them. It's a pretty big difference. A testamentary trust structure can also provide some beneficiary if you have beneficiaries. Sorry, let me say that again. A testamentary trust structure may have additional benefit if any of your beneficiaries have bankruptcy issues, and might protect your hard-earned assets from their business creditors. And that's a structure, you know, if you have children or family members, beneficiaries who maybe have significant personal liabilities of their own, maybe as, say, directors of companies, they might have had to give significant personal guarantees for the company that they're a director of or that they're associated with. And having a testamentary trust structure might assist in ensuring that your family inheritance stays with the family and doesn't become available to those creditors or to those business claims. There are, in some circumstances, some benefits even in a family law situation if one of your children or beneficiaries were to subsequently go through a separation or divorce and financial separation. Those benefits are a little more limited, and so we wouldn't usually recommend this structure as an answer to that problem, but sometimes there can be some benefits in doing that from a family law perspective as well. But yeah, I say that very advisedly, and they are complex structures, testamentary trust wills, and so that's something certainly that you definitely need a lawyer involved with. You wouldn't want to try doing that yourself for sure. So there's some of the key factors to think about as you go about making a will, as you have those discussions with your husband, with your wife, with your family, and you consider that. Obviously, however, a will only comes into effect if you're dead. And so prior to that point in time, it's really of no legal significance whatsoever. It's a piece of paper that has no operative effect until you've died. And so the situation can arise where you're not dead, but you're not able to make decisions either. And so that's where we come to the whole area of powers of attorney. And again, powers of attorney are not addressed by your will. They're quite separate to your will, but they should be considered as part of your estate plan. Powers of attorney, generally speaking, and now I'm specifically talking about enduring powers of attorney, which is a type of power of attorney. Enduring powers of attorney endure beyond the loss of the capacity to manage one's own affairs. They're specifically designed so that if you're not able to make decisions any longer for yourself, you've already given authority to someone to do it on your behalf. The role of an attorney ends on the death of the person who made the power of attorney. We usually call them the appointor or the principal. So the role of that attorney ends on the death of that person, and the role of the executor begins at the death. So there's never any time that the attorney and the executor are making decisions at simultaneously. Power of attorney until the point of death. Once the principal person dies, then the executor steps in. Sometimes, commonly, in fact, you'll appoint the same person to those roles, but they are very distinct roles, and they don't overlap at all. And there are two types of powers of attorney. There's the financial power of attorney, and then there's the personal power of attorney, and I'll go into those in a little more detail in a moment. But firstly, just to address this question of why you need an enduring power of attorney, and look, this is one that I cannot overemphasize. I think I couldn't tell you the number of times I've sat with clients, and they've said, no, look, I want to keep it simple. I don't want to go into that. I don't need that. You know, my family are all really functional and they're not going to argue. There's not going to be any problems. Just do a power of attorney, please. It's really not difficult, and it can really save your family, your loved ones, a lot of trouble. Having an enduring power of attorney is necessary to ensure that your interests are advanced by your trusted representative. It's something you do while you're able to have a say, and it often will come into effect when you can't have a say. And by that stage, it's too late. So if you want someone in particular to be able to make decisions for you and you don't want someone else doing it, then you need to say that now while you can. In many circumstances, if you're facing aging or if you've got incapacity, banks, residential care facilities, hospitals, they'll require them to be on file. And I've had people who, they've said, no, I just want to do a will. And then 3 years later, when they're going in for day surgery or they're being admitted to an aged care facility, they come in a huge flap and hurry and say, oh, we need these done, we need these done. And it's like, you could have really avoided yourselves the stress. Let's just do it. Powers of attorney can also have impact on your company. If you have a company structure, they can have some degree of control in your self-managed super fund or in your discretionary trusts. And so many of those same considerations I mentioned earlier with the executors should also be considered when you're talking about powers of attorney. So in Victoria, there are two types of enduring powers of attorney. There's a third area of decision making I'll come to in a moment, but in Victoria we have these, so it's really three areas, but two are called powers of attorney. If you're tuning in from another state tonight, then you might have a slightly different regime, but every state in Australia has similar kind of arrangements. They're not identical, but they are broadly similar. And so the enduring power of attorney for financial matters allows your attorney to effectively deal with any legal matter that relates to your financial and property affairs. So we're talking about properties, and that can include buying property, that can include selling property, renting property. It can include your bank accounts, withdrawing funds, making transactions. It extends to really any of your assets, buying, selling shares, making investment decisions, paying expenses. There's really not a lot that your financial power of attorney cannot do on your behalf. And, I often tell clients, you should consider it as if you're handing over your keys, your wallet, your PIN number, your passwords. There's significant access. I did see, I won't answer all the questions yet, but I did see one question pop up there asking if there'll be a copy of the slides available, and yes, we will be able to circulate that along with the recording afterwards. So yeah, there's the financial decisions that attorneys can make. It's not a matter of settled law yet. Different states in Australia have slightly different interpretations of this, but I expect that we'll see it settled that attorneys even can make decisions about superannuation and making death benefit nominations. Very significant powers. Then you talk about personal powers of attorney, enduring power of attorney for personal matters. And this one's a little bit more grey. It's a little bit harder to pin down sometimes, but you could think of it as the decisions that relate to someone's daily arrangements, day-to-day care and living arrangements. So it includes, if they have to be in aged care, which one, what sort of care will they receive, what kind of services will be provided, what are their living arrangements. If you had someone who maybe was younger, but they had, say, something like an acquired brain injury or something like that, then it might be questions of whether they should participate in courses of education or employment. Those sort of arrangements that aren't strictly speaking financial transactions. And so you could have a situation where the decision maker for personal matters will decide what arrangements are made and which care providers you go with, and then the financial attorney might be the one who has to pay for them. I do emphasise, however, that this doesn't include medical treatment decisions, and they are dealt with as a separate authority. So we'll talk about those in a moment. With the powers of attorney, though, they are very flexible and they can be tailored to your circumstances. You can appoint more than one person. You can say that if you have multiple people, they must act jointly, so they all have to be involved in every decision. You can say they have to act jointly and severally, which means that while they all have equal authority and you'd hope they work together, as a practical arrangement, you can let just one make a sign off on a decision or transaction. You can even have it to be acting by majority. So, for example, if you had 3 people, then you could say any 2 of them can make a decision. You can have principal people, principal attorneys, and then you can have substitutes or alternate attorneys. You can specify when you want the power of attorney to commence. So sometimes it might begin immediately, which could be helpful. Someone can go do your banking for you and sign documents on your behalf. More commonly, people will say it begins if I lose legal decision-making capacity or some version of that. You can even put in some other circumstance that you really want, like if you were traveling overseas or something like that. There's also scope under the legislation to appoint someone who's not an attorney, but who's called a support person. And you might empower a support person to be able to access information or to communicate on your behalf, but not actually make decisions on your behalf. And so in some circumstances that may be helpful if you had someone who was maybe physically challenged, largely housebound or something like that. And it might be really helpful for them to have a family member who can communicate with Centrelink or the bank or whatever agency that needs to be communicated with, but while the principal person themselves still retains the authority to make decisions as they see fit. So there's a lot of flexibility there. And what we increasingly are seeing is necessary is tailoring also the powers of the power of attorney. In some cases, we're allowing the attorneys to make specific transactions on behalf of the principal person. Sometimes we're allowing them to enter into a transaction that isn't strictly speaking for the benefit of the principal, but might be for the benefit of the attorney. And that can be really important in, for example, a husband and wife scenario. If the wife needs to be able to use the husband's assets for her own benefit, strictly speaking, that may be a breach of her duty as an attorney to act only in the interest of the person who's given the authority. But if all the assets are in the husband's name, she needs to be able to access those. So we might put that in. Sometimes we'll specifically include powers to deal with superannuation or companies or trusts or to give gifts or to provide for other family members. So these are some of the things you need to discuss with your lawyer and to make sure that the document really does anticipate your needs and reflects accordingly. So as I said, in Victoria right now, we have the enduring power of attorney for financial matters, the enduring power of attorney for personal matters. And if you've got the same people, then often for both roles, then often that'll be addressed in the same document. But the third area of decision making is medical treatment decision makers. And this is what previously was called medical powers of attorney. And a few years ago, they changed the legislation and some bureaucrat thought that this name rolled off the tongue better. So we have appointment of medical treatment decision makers. This document is strictly about providing instructions for medical treatment on your behalf in the circumstances only that you're unable to do that. It also allows the medical treatment decision maker to obtain information about your medical treatment and medical records and so forth. And it operates quite similarly to the enduring powers of attorney, although there are some differences. With the medical treatment decision maker document, you can only ever appoint one person at a time. So you can have a cascading list with a few different names in it, but there's only ever one person authorised at a time. And I presume that's because the doctors didn't want a situation in a life and death situation where there's a fight between the appointed decision makers. They need to be able to know who to talk to, who has the authority to give them instructions, and to be able to rely upon that. Your medical treatment decision makers may be having to provide consent for surgical procedures or particular courses of treatment. They may need to make decisions about some of the care that you would receive if you were unable to tell the doctors yourself. And in an end of life scenario, they may be the ones to convey your wishes about whether to continue treatment or withhold it, to turn the machine off, as it were. So it's a significant responsibility, as they all are, and it's one that you want to be very thoughtful about, appointing people who you rely upon, whose discretion and trust, whose discretion and judgment you trust, and also who will be able to handle the responsibility. It's a significant one, and one that you want to be very careful in delegating. That is at a high level a summary of some of the factors that you should consider in an estate plan. And I can see that we do have some questions here, so if I can find them, we will endeavour to answer these. And often as I answer the questions, you'll have more. So please feel free to keep tossing those in, popping them in either the chat or the questions box there, and I'll do my best to get through them. The first question here is, how does something like Safe Will compare with setting up a will through a local law firm? Yeah, it's a good question. There's been a lot of advertising from quite a number of these organisations of late. I suppose also by extension, you know, this is sort of the modern take of the old post office will kits, which you might have seen and maybe some of you have done. I can't say that I'm incredibly familiar with the Safe Will process, although I have seen deceased estates that involved one of those sorts of wills, and I've also been involved in litigation that involved some of those wills. And look, I suppose that this may sound self-serving, but the response I typically give to whether it's a will kit, whether it's an online kit or something like that, is that they work often enough to be dangerous. That is to say, if they never worked, you wouldn't be able to use them at all and you'd never have any problems from them. They can be fine in some circumstances, or if you fill it out correctly, or if you precisely identify all the information and you've thought through all the circumstances, it can be no problem at all. But when it falls apart, or where it falls apart, is where there's been something missed, something overlooked. I couldn't tell you the number of times I have a call and someone says, I just need a simple will. And then we start asking questions. One of my colleagues here had a client just a few weeks ago, and they were so emphatic that I just need a simple will. And so she sat them down in the room and she started asking questions, and then she started asking more questions and probed a little deeper, and the client sort of seemed a little evasive and didn't really want to answer the questions. And she said, look, I need you to be honest with me. What's the situation? And then it transpired as my colleague asked the questions. It turns out that actually it was a second marriage, and there were children from a prior relationship, and there were all kinds of issues, and there was estrangement, and there were people with conflict waiting in the wings, and just all of these issues that the client on his own assessment didn't think were relevant, and they were hugely relevant, and without someone to push and dig and pry and get to the issues that the lawyer understands are relevant, then that would have been overlooked. And if he had had a simple will based on what he'd said in the first 10 minutes of that conversation, it would have been just disastrous. So all of that to say, it can work, it can be fine until it's not, and that's when I get a lot of my work, unfortunately. I'd be very happy not to have to deal with it. Thanks for the question. Another question here is, a parent has appointed 2 adult children to be joint and several attorneys for the power of attorney, personal or financial. What are the avenues for resolution available if the 2 attorneys do not agree with each other on a decision, or if one starts to make individual decisions? Are there requirements for both to agree with each other? Yeah, very, very good question. If you were sitting in my office and I was taking instructions for your estate plan, and we were having the discussion and giving you the advice, one of the things I always emphasize when you're looking at multiple executors or multiple attorneys is that it can be brilliant if they get along really well. They've got that mutual support, there's mutual accountability, and that can work really well. It can also turn to custard. It can become so toxic. And some of my worst stories are executors who literally are fighting over $300 worth of costume jewelries, and they'll go back and forth for 4 months and will spend $8,000 in fees just because they can't agree. And I had one matter one time where these two brothers, they were executors together. They had it was quite simple, really. Mum and dad had some assets. They both died. $2 million. The boys had already dealt with basically everything. They received $1 million cash each, and all that remained was this single parcel of shares worth, say, 45 grand. And one of the executors said, I think we should hold on to them because I think they're going to go up in value. And the other one said, look, I just want to wrap this up and move on. Can we just sell them and get out of here? And we went back and forth, and you know, the answer came back. I had a suggestion for them. I said, why don't we just split the shares and into 2 parcels, and then you can each receive those and you can do what you like with them, sell them, keep them independent of each other. And they said, no, if we do that, we're going to have to pay the broker twice to handle this, and it's going to be an extra $150. And I mean, literally, I'm not exaggerating. These guys just received $1 million. And obviously, you know, as I waded through it, we talking to them, and it comes down to the relationship. And one of them, I remember the conversation. He says, no, his whole life he's gotten his own way, and that's it. I'm putting my foot down now. He's not going to push me around any longer. And literally, we're talking months of delay, thousands of dollars of legal fees, just trying to get the executors to agree on something, because nothing could be done till they agreed. All of that to say, and sorry, I'm distracting myself. All that to say, it's a little bit different between powers of attorney and executors. And so if you're talking about joint and several attorneys, there are options available. So if the power of attorney's already been made and we're presuming the parent has now lost capacity, at the end of the day, there is recourse to VCAT. VCAT has jurisdiction to review powers of attorney, decisions by attorneys, conflicts between attorneys, and even to remove attorneys if that's what needs to happen. It's better if you can avoid that, obviously, but sometimes you do get a situation where one of the attorneys has taken control of everything. They've, you know, maybe locked the other one out. They don't have access to bank records or transactions or information, and sometimes VCAT's the only real option in that case, particularly if you're concerned that the attorney's not making decisions in the parent's best interests. If it's joint and several, there's an expectation they work together, but as I said, there's no legal requirement that they both sign off on everything. So it is possible for one person to sort of run off on their own, and there are no requirement for them to actually agree with each other. So if they're not able to sort it out, I would probably say that VCAT's the only real option there, unfortunately. And in some cases, VCAT will have a look at the whole situation and they'll choose one over the other, or they might change the power of attorney so that it has to be joint and they must both be involved, or VCAT might say the whole thing's too toxic, you guys can't work together, don't trust either of you, we're going to get rid of you and appoint someone else entirely. Next question, and thank you for the compliment, attendee. I'm glad this is helpful to you. How do alternate lists work, and can you do this with people who give you powers of attorney and with executors? So yes, the answer to both is that you can cater for a few different scenarios, and so you might say, I want this person to act, but if they can't do it, then I'll authorize this person or these people to act, and you may continue. And that's the same for executors. So the most common one you'd see with for a will is you might see, you know, husband and wife to one another in the first instance as the executors, and then one or more of the children or something like that in your stereotypical traditional family structure. Next question, based on what I've observed in litigation, what are the key things that clients or lawyers miss when giving instructions or drafting submissions that give the other side leverage during litigation? It's a huge question. What are the key things that clients or lawyers miss when giving instructions or drafting submissions that give the other side leverage during litigation? I think that I don't know that I've got a great answer for this one, and if this is an aspiring law student or something like that, I particularly apologise. I do think that I do see situations where I see people get involved in litigation when perhaps they shouldn't be. And I don't know if it's because they've got unrealistic expectations. I don't know if they're receiving poor advice from their lawyers. I don't know if it's because they're ignoring the advice of otherwise good lawyers. But I do see situations where parties are getting involved in litigation where they shouldn't be doing it. It's just not a good idea. They don't have the claim that they think they have, or they don't have the evidence that they think they have, or sometimes they're just having a fight over something that's just not commercially realistic or viable to have a fight about. I remember one matter I was in that was we call it a testator's family maintenance claim. That's where we say, look, the will, yes, sure, the will is valid, but I think the deceased should have made greater provision for me. And it's a very common type of dispute that arises out of estates. The law says that a will maker has a moral duty or obligation to make provision for certain family members. And again, that's part of the advice that should be sought when you're making your will, particularly if you want to leave someone out. But in this case, the other side had a really, really weak claim. My client was the widow of the deceased. She was in a long and loving relationship with him, and there were really no issues. And they'd made this claim, and it was a stupid claim. They shouldn't have made it. But and we wrote to them many times. We tried to advise them of that. And in that case, I think it was the lawyer that they had involved. It was just a general practice lawyer who probably had not done a lot of this type of work before. And so the court ordered us off to mediation, and we got to mediation, and we sat, my client and I, we sat in the mediation room waiting, and the mediator came in and said, oh, the other side have just got a new barrister. This is the first time they've had the opportunity to meet this barrister, and so can you just give them another half hour? We said, fine. And we sat there and waited and waited. We waited for 2 hours because it was the first time that they'd actually spoken with a lawyer who knew this area of the law and was giving good advice. And so we sat there for 2 hours, and after 2 hours, the mediator came back in and said, they've made an offer. The offer they made was a complete capitulation, and it was basically what we'd been offering all the way along, and just, you know, the unnecessary costs that have been incurred. So I think key things would be getting good advice, getting realistic advice, and understanding the limitations of the law, that sometimes, you know, the law can do some things, but it can't repair the past. It can't resolve all your past grievances. I've had people sit and they've, you know, recited that he didn't send me a birthday card, and then I invited him for Christmas and he didn't come. And it's like, I understand the hurt of that, the pain, that's very real, but the law won't necessarily have an answer for you there. Anyway, thanks, attendee. You've distracted me. I'll keep moving, and we've got a few more, so we'll try to get through. Is there a way of providing for future grandchildren in a will without having to change the will every time a new grandchild is born? Yes, there is, and it's common. Usually, though, you'll set it up so that it'll provide for all. It's very easy to set it up so that it provides for all grandchildren who are born by the time of death. So you can say, at the time of my death, then there may be X dollars per grandchild, or maybe there's a portion of the estate which is shared by all of the grandchildren, whoever they may be. So that's easily done. If you're talking about trying to provide for grandchildren who will be born after you die, that's a lot more difficult. And if you were to try to do something like that, it would have to be by way of some pretty funky trusts. The reason being, an executor needs certainty. They're meant to administer your estate. They're meant to distribute within a reasonable period of time. So they can't hold uncertain amount of money for another 30, 40 years. Who knows how, it depends how old the children are, you know, and how old will be the grandchildren. In law school, we used to talk about the fertile octogenarian. Just because they're 80 doesn't mean they can't have a kid. So the executor needs some certainty. So you really need a cut-off date to be able to say, okay, by this time, whoever's alive, they get this much money, and it needs to be able to be wrapped up. Moving on, how's the lawyer informed when an individual passes away? Presumably family members need to know which lawyer is holding the will. This is a very, very good question, and it's one which perhaps does need some attention from governments, and every now and then we get a bit of chatter about how it needs to be attended to. It would make sense if there were a single register of wills where everyone submits their wills, and then when someone dies, the will can be found. That's not the case. And so people will sometimes have their wills with their lawyers. That's very common. Sometimes they'll have it at home, somewhere tucked away in a filing cabinet or in a drawer. Sometimes it'll be even in a bank safe deposit box or somewhere else. And if no one knows where to find it, then they won't find it. I had a client one time, and his brother died. My client didn't even know the brother had made a will. My client didn't even know that he was the executor appointed in the will. He just happened to be looking through some documents on the kitchen table after his brother's death and found the will just sitting there. So it's a good idea to, if you make a will, make sure the people who need to know where it is. Our standard practice in our office is that when someone makes a will, we encourage you to leave it with us so it can be found, and then we'll give you copies and say, look, circulate these copies to everyone who needs it. They'll know where to find the original, and that way everyone knows. But otherwise, unless someone tells us, we don't know either. There is an option of filing wills with the Supreme Court, and it's actually can be a very good idea, particularly if you are concerned that someone might find your will who doesn't like your will, and they may be motivated to make that will disappear. That's a criminal offence, but I'm sure it happens. So you can file your will with the Supreme Court, and that way it will be found, but not many people do that. It's an option though. Moving on, yes, so one of my business partners here. Hi, Madeleine. Madeleine's a very experienced wills and estates lawyer, and she also leads our team here, and she's confirmed VCAT will review disputes between attorneys. And I think there was another question over on the other page here. Are online wills good, though, for someone with no dependents and not being married? Yeah, good question. It's really interesting, particularly when you've got someone who's, yes, single or no dependents. I had one estate one time where a very young guy, from memory, he's 22, 23 years old, died, had some congenital heart condition that no one knew about, and he just literally just keeled over one day, died. And you would have thought he owned nothing in the world except his car, which was heavily financed, and he owed so much money. He owed more than the car was worth. But the thing about this young guy was that he struggled to keep a job. And so he'd go work for sort of 12, 18 months somewhere, and then he'd leave or be fired or whatever and move on to the next job. And so as a consequence of that, when he died, every time he went to a new job, the employer would sign him up with their sort of standard superannuation provider. And so he didn't really realise it, he'd never given it any thought, but he actually had three superannuation, different superannuation funds when he died. And in each of them, he had enough money to keep paying the life insurance that was part of the superannuation. More recently, the government has made that not a default option, but many funds it used to be. And so when he died, he actually had about $350,000 that no one knew about. And his parents were separated. And there was a huge fight between them about who got that money. I also had one matter where, again, quite a young guy, single, was killed in a motorcycle accident. and he had a girlfriend, and this is where having a will is really a good idea, because under the law of intestacy, in order for someone to be considered a partner, they have to have been in a genuine domestic relationship, and there's various terms around that. So it doesn't necessarily mean they were always living together either. And they had to have been in a relationship for 2 years uninterrupted. And so there are all these issues of, well, were they actually living together for this time? Was it actually a domestic relationship? What about that argument they had? Was that a break in the relationship? Was that just and it can be so messy. And obviously, or maybe not obviously, but in this case, the parents were of a view that that wasn't a genuine relationship and hadn't been, and the young lady involved, she was the view that it was very very genuine and had been well over 2 years. And again, so there's complexity and uncertainty, and whenever you bring uncertainty into it, there's scope for dispute and litigation. So to answer the question, are online wills good enough? Again, they can be fine until they're not, and then it all turns into a lawyer's picnic. Sorry, it sounds so cynical. The next question also, do you have to have the power of attorney forms certified by a lawyer or solicitor? No, you don't. Powers of attorney, though, do have to be witnessed by the specific rule, I think, if I put it correctly, is that powers of attorney must be witnessed by 2 witnesses, and one of those witnesses must be authorised to witness affidavits, not statutory declarations, affidavits, except it can also be medical doctors. So there's a few other carve-outs, but generally you need to go see someone like a lawyer, a JP, a medical doctor for powers of attorney. That's okay. There are some other rules about the witnesses as well, so you have to be careful with that. Another question here, and this might be our last one, unless someone sneaks in, but you've done well in staying with me. So a parent has appointed 2 adult children to be joint and several. Oh, this is the same question, I think. Okay, great. This is the same question we asked earlier about potential conflicts between the powers of attorney. And sorry, I'll just hit publish on these in case anyone wanted to see those. So unless I've missed anything else, there's one more here. Is the most appropriate time to create a will to draft it when you're starting to head towards old age, when you have more assets? I assume drafting a will is pointless when you have no or limited assets. And hopefully my last 2 stories there will provide some insight. Again, you sometimes have people who don't realise the assets that they hold, and you know, I was talking to a lady just today. Her brilliant plan. I mean, she's got a disaster waiting to happen. There are stepchildren from her late husband. There's potential litigation. There's a fair bit of money involved, and I'd be almost willing to bet my last dollar that if she doesn't do something carefully, there will be litigation upon her death. And her plan, as I spoke to her today and said, look, you know, this is what I think you need to do. She said, oh, that sounds too hard. I want to keep it simple. So what I'll do is before I die, I'm going to pull all the money out of super and out of all my accounts, and I'm going to just give it away, which is a nice plan if you happen to know exactly when you die or when you're going to die. And if any of you have a crystal ball, please let me know, because I'd love to know the price of Bitcoin in a year's time. Final question, what is the cost of a will? Well, that's a great question. Look, it does vary. It can vary depending upon some of the things I've mentioned tonight: complexity, families, relationships, whether you're going to be looking at testamentary trusts, whether you need rights of occupancy, whether you need to look at strategies with superannuation and different things. So look, depending, it can range, and look, you'll find any number of prices out there. In our office, I think typically a will can start from sort of $660 up into thousands of dollars if there's a lot of complexity and a lot involved behind that. If you ever want to know, you're welcome to give us a call. and have a chat with us. We can quickly figure out sort of what's involved and give you some ballpark figures there. And then once the lawyer sits down and goes through it with you, they'll be able to drill down and provide a lot more detail about that. Thank you so much, everyone, for your questions. We're at 8:01 now, so I don't want to keep you back from your dinner if you haven't quite got there, or your evening's cuppa, or whatever it is you have. We're glad that you're able to join us as part of this Law Week event, and I hope the information's been helpful to you. If you do have any other questions or anything you want to know, please don't hesitate to reach out to our office. Finally, we do have a survey, and if you'd be happy to stick around for 30 seconds and give us your feedback on how we could help or make these presentations more valuable in the future, we'd be very grateful for that. But otherwise, from all of us at Hutchinson Legal, thank you so much for joining us tonight. We're glad you could, and we wish you all the best. Thank you. Good night.